Good afternoon, Deputy McLeish.
Good afternoon, Your Honor. How are you doing, sir?
I'm doing fine, and yourself?
No, doing pretty good.
I see you're still wearing many hats.
Yes, sir.
I guess maybe that'll keep your hair from falling out.
Oh, I think of the Wizard of Oz. If only I had at least one brain to fill one of those hats, it would be a better day. Working on it.
You still getting people in queue?
No, sir. Actually, we've got Mr. Knoll with 2 clients who are present. If you don't mind, if we could get those 2 out of the way first.
Absolutely. Who you want first, Mr. Knoll?
Judge, I got Mr. Powell and I've got Mr. Perry. Either's fine, whichever the court wishes to call first. Our papers are done.
And we're doing pleas on both, correct?
Yes, sir. They'll both be going into custody.
Okay. We'll just go ahead and go on the docket. We'll go with Mr. Perry.
Mr. Perry. Mr. Perry first.
Mr. Perry, I'm sorry. Mr. Perry.
And Mr. Knoll, before we go on the record, can you just go ahead and tell me what the terms of the plea are?
Judge, on Mr. Perry's case, 8 months state jail. And the fine is, forget it, $1,500.
What cost?
$290.
$290?
$290, and restitution is $180 on the lab.
Any credit?
Reimbursement.
Any credit time?
I think that's just 1 day, Your Honor, is what it indicates.
He'll be pleading to state jail PCS, correct?
That's correct, Your Honor.
All right, and you and your client have signed throughout the paperwork, is that correct?
We have, Your Honor.
Okay.
He's here. Not that long.
All right, court's going to call CR 20267, State versus Thomas James Perry Jr. Mr. Perry, will raise your right hand. I'm going to place you under oath. Mr. Perry, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you put your hand down. You are, in fact, Thomas James Perry Jr., are you not?
Yes, sir.
And Mr. Perry, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Kurt Knoll. Do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything regarding your plea agreement today that you do not understand?
I don't believe so.
Throughout the paperwork, your signature appears. Are you telling me that it's a true and correct signature and that you've only signed those documents once you understood what you have read and signed?
Yes, sir.
Mr. Knoll, do you believe your client to be competent today?
I believe so, Your Honor.
And you explained to him his legal and constitutional rights?
Yes, Your Honor.
All right, Mr. Perry, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. That carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC. Do you understand that full range of punishment? Do you understand that full range of punishment, sir?
Yes, sir. I understand.
Okay. And you heard Mr. Knoll tell me what the plea agreement was. Is that your understanding of the plea agreement?
Yes, sir.
All right. So at this time, Mr. Perry, I'm going to ask you, how do you plead to the state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram?
Guilty.
Mr. Perry, are you pleading guilty because you are guilty of that offense?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this offense?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Knoll, any objection to States 1, the stipulation of evidence?
No, Your Honor.
All right, States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Ms. Heisel, can you give me just a brief summation to support the plea? I don't have the plea papers with me.
Yes, Your Honor. Mr. Perry was the driver of a vehicle that was pulled over for multiple traffic infractions. The officer, upon speaking with Mr. Perry, believed that Mr. Perry might be under the influence of some narcotics, asked him to step out. Ultimately, the officer patted down Mr. Perry for safety, and there was a cigarette pack that was in Mr. Perry's shirt. He handed it to the passenger in his car, but based on the interaction between them, the officer searched inside of that cigarette pack and found a baggie of methamphetamine. Mr. Perry then basically snatched the cigarette pack away from the officers and evaded on foot and did get away from the officers.
But there's only one charge that the state's proceeding on, correct? And that's the possession charge?
That's correct, Your Honor. I believe, this is Mr. Woodwhite's case, but I believe that the tampering has already been declined and that the misdemeanor evading arrest is going to be dismissed by our office.
Okay.
That would be my understanding. I think actually there was, if I recall in the video, he attempted to snatch back whatever the methamphetamine was not successful, so maybe that's why the tampering was declined, as I recall from the video.
Thank you, Mr. Knoll. All right, then based on the evidence presented to the court, I find that there is sufficient evidence to convict the defendant of this offense, and the court does convict Mr. Perry of possession of a controlled substance in penalty group 1 less than 1 gram. Court will assess his punishment in accordance with the plea agreement at 8 months confinement in the State Jail Division of TDC, assesses a $1,500 fine, $290 court cost, $180 restitution, and the court awards Mr. Perry 1 day credit towards that sentence for the time that he has served in jail on this cause. Mr. Perry, whenever you're released from TDC, you need to make arrangements to discharge what you owe the county in your fines and court costs. Failure to contact the court and pay those at once or to get on a payment plan will result in the court issuing a warrant for your arrest. Do you understand, sir?
I understand.
All right, Mr. Perry, you're hereby remanded to custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. If you haven't been fingerprinted, I'm going to have you go with the bailiff to be fingerprinted. If you have been fingerprinted, then you'll be taken into custody at this time. All right, Mr. Powell.
Yes.
This is cause number CR 20268, State versus Jeremy Ray Powell. And Mr. Knoll, can you recite the plea agreement for me?
Judge, the plea agreement in this case is 4 years TDC, a $2,000 fine. There is no restitution. Court cost is $290 and a $35 reimbursement.
Any credit time?
Yes, that was 48 days.
Is he pleading to the charge of sexual assault of a child?
He is, Your Honor.
And has Mr. Powell signed the admonishments regarding sex offender registration requirements?
He has, Your Honor.
Okay, and has he been provided with a copy of Chapter 62?
We have a copy in the plea papers, and I'll get those to him now.
All right, thank you. All right, Mr. Powell, right hand, I'm going to place you under oath. Mr. Powell, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, you put your hand down. All right, Mr. Powell, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Knoll. Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about your plea agreement that you do not understand?
No, sir.
Throughout the paperwork, if your signature appears in there, are you telling me that that is your true signature and you've only signed once you understood what you were reading and signing?
Yes, sir.
Mr. Knoll, do you believe Mr. Powell to be competent today?
I do, Your Honor, and if I could, he has no prior felonies. He is eligible, as they say, for probation. He and I have discussed that issue several times on the phone and in person in my office. Based on the type of charge and the facts of the case in the offer, we decided, or actually he's decided, that he would accept the plea offer as opposed to potentially go to a jury on a punishment issue.
Okay. And so you've explained all of his legal and constitutional rights to him also?
I have, Your Honor.
And you've gone through the discovery with him?
Yes, we have. There are
Okay.
several videos, as I recall.
Okay.
Some other photographs, I believe, and other documentary evidence.
All right, Mr. Powell, the grand jury returned an indictment in this case, charging you with the second-degree felony offense of sexual assault of a child. That carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice. Do you understand that full range of punishment?
Yes, sir, I do.
That means any plea agreement that you reach or any sentence that's handed down by the court or a sentence that would be handed down by a jury must fall within that range. Do you understand that?
Yes, sir.
And based on what Mr. Knoll has told me today, the plea agreement that you have reached with the state does fit legally within that range of punishment. So at this time, Mr. Powell, I'm going to ask you, how do you plead to the second-degree felony offense, sexual assault of a child?
Guilty.
And Mr. Powell, are you pleading guilty to that offense because you are guilty of committing that offense?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this offense?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Knoll, any objection to States 1, the stipulation of evidence?
No, Your Honor.
All right, the court admits States Exhibit 1 and takes judicial notice of Mr. Powell's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense, Mr. Knoll?
No, Your Honor.
All right, and the court will find that this is an offense requiring registration under Chapter 62. And if the court approves the plea agreement, we'll find that Mr. Powell has been provided with a copy of Chapter 62 and is aware of the requirement that if the court approves the plea agreement, that he'll be required to register as a sex offender for the rest of his life. All right, at this time, Ms. Heisel, can you give me a brief summation to support the plea?
Yes, Your Honor. While investigating a separate sexual assault of a child, the 16-year-old victim makes an additional outcry that a couple of weeks before the interview, he had had sex with Mr. Powell in his driveway. He told the officers that he met Mr. Powell on the social media site Grindr and provided some messages to them that was consistent with that. And then following that outcry, Grand Saline issued a warrant for Mr. Powell's arrest.
Any objection to that summation, Mr. Knoll?
No, the only thing I'd add, Judge, is the victim in the case was, I don't remember exactly how many months, but a few months short of his 17th birthday. So that's why we are here today.
Thank you, Mr. Knoll. All right, then based on the evidence as it's been presented to the court will find that there is sufficient evidence to support this plea agreement. Court hereby convicts Jeremy Ray Powell of sexual assault of a child, assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice, assesses a $2,000 fine, court costs $290, orders reimbursement fees of $35. Court awards Mr. Powell 48 days credit for the time that he has spent in jail on this cause. Court finds that this is an offense requiring registration under Chapter 62. And has the age of the victim been identified in the judgment as required by law? Should be about halfway down in the middle. Middle.
Judge, I don't, if it's here, I don't see it.
Keep reading. It should be almost directly in the middle of the page underneath the plea agreement. There should be Chapter 62 language and an age and I believe, the sex of the victim.
I do not see that, Your Honor.
If that's not, then we'll need to get a new judgment prepared.
Judge, would the court want me to just write that in? I'm aware of both.
No, we'll need to get that typewritten, so there's no objection by TDC. Mr. Knoll, you've also told me that the supplemental sex offender admonishments have been included in the plea agreement, correct? Whereby
They are,
Mr. Powell's acknowledged lifetime registration requirements upon being released.
yes, and he's put his initials under each one as they are numerically set out, I believe it's 15.
All right, thank you, Mr. Knoll. All right, Mr. Powell, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the plea agreement. If you've not been fingerprinted, I'm gonna have you go with my bailiff to be fingerprinted at this time, and then you'll be taken into custody. Once you get out of TDC, Mr. Powell, it's important that you do two things, and you'll receive additional information about this from TDC. But first and foremost, whenever you are released, either on parole or when you have extinguished your sentence, you're going to be required to register as a sex offender. So whichever law enforcement agency, whatever community that you're discharged to, if it's a city, you'll need to check with the police department there and make sure that you register. If you're in a county area, whoever the county sex offender registration officer is, you'll need to report to them immediately and begin your registration requirements. Secondarily to that, you'll also need to contact the Van Zandt County Courthouse so you can make arrangements to discharge your fines, court costs, and reimbursement fees. Your failure to do that will result in the court issuing a warrant for your arrest. Okay, so once you get out, if you'll just contact the courthouse and tell them you need to make some payments on your fees, you'll be directed to the right person. And then the county will work with you in discharging those through a payment plan. You understand?
I do.
Okay. All right. You'll go with the bailiff at this time.
And Judge, Miss Abney said that she can correct that. Would the court prefer she send it to Patty or Peggy, the corrected front page of the judgment?
Send it for me, please.
Did you say Patty?
Patty Taberham, yes.
Okay, thanks, Judge.
And Your Honor, we have Mr. Gimbel and his clients in the room ready if you're ready for them.
I am. Mr. Gimbel, who will be up first?
We have Terry Lee Elmore, Your Honor.
And do you have a copy of the indictment today, Mr. Gimbel?
Yes, we do, Your Honor. Yes,
All right.
we do, Your Honor.
All right. This is cause number CR 20-420 and 421. State versus Terry Lee Elmore was set for arraignment today. Go ahead, Mr. Gimbel.
We have received a copy of the indictment. I've gone over that with Mr. Elmore. His name is spelled correctly. He understands all the language in that, and he waives formal readings. And we just ask for the next pre-trial setting, Your Honor.
All right. Court will set Mr. Elmore for pretrial. Are you available on April 13th? Mr. Gimbel, I want to give you a little bit more time since you've got two cases here and give you more time to get through the discovery.
I will be, Your Honor. Thank you.
Okay, so we'll set Mr. Elmore then for pretrial on April 13th at 1:30 p.m. if Mr. Elmore is in jail. If Mr. Elmore makes bail in this case, then all settings will be at 9 a.m. via Zoom. And the court
Thank
will
you, Your
find,
Honor.
and the court will find that Mr. Elmore has entered a plea of not guilty, and the court will enter that into the record.
Thank you, Your Honor.
All right, thank you, Mr. Elmore. You can have a seat.
Next, we have Norman Wayne Hansard.
Thank you, sir.
He is set for pretrial this afternoon.
All right, this is cause number CR 20-339, State versus Norman Wayne Hansard. Go ahead, Mr. Gimbel.
We have filed a pretrial motion, and I have already visited with Mr. Woodwick regarding the matter, and I believe we will request a contested hearing on that matter.
That's a motion to suppress, correct?
That's correct, Your Honor.
Yeah, I think I saw that in e-file. All right, the court will set this for an evidentiary hearing on March 30th. And that will be at 9 a.m. All right, and so that'll be at 9 a.m. Obviously, if Mr. Hansard gets out of jail between now and then, it'll still be at 9 a.m. and he can report to the courthouse. If he's still in custody, then if you need that to be an in-person hearing, Mr. Gimbel, then you can request the court to make some findings. If not, then we'll just we'll conduct the hearing via Zoom.
That sounds good, Your Honor.
And Judge, I believe that this is the case. Mr. Woodwick's not feeling well, but I believe this is the case. Mr. Woodwick said that we had not received a copy of the motion, and he was trying to see if that was perhaps because the court hadn't accepted the filing yet. I think usually when the court hasn't accepted the filing, it won't serve us until after that's happened.
I believe I saw it yesterday and I returned it to the clerk for filing, but I thought once the clerk accepted it, that it should have been, the notice should have gone out. I don't know that, I'm not sure. I'm not sure if e-files requires me to do anything to denote acceptance.
Okay, I'll look on the clerk's side and see if we can't pull it on our side from the clerk.
Okay, and if not, Mr. Campbell, will you email Ms. Heisler or Mr. Woodwick?
I will, Your Honor. I submitted the motion on February 9th, I believe, and I received notice this morning that it had been accepted by the district clerk.
Okay, then
Then I'm
perhaps,
sure Mr. Woodwick has it.
well, then that may be the case then, because I saw it yesterday. And once I saw it, then I forwarded it to the clerk for filing.
Thank you, Judge.
Mhm. Who's next, Mr. Gimbel?
And last we have James Thompson.
All right, this is cause numbers CR 20-313 and 314, State versus James Matthew Thomason. I show that we were set for docket call and possibly a plea today. What's your announcement, Mr. Gimbel?
Judge, we have received all discovery material and a plea offer, and Mr. Thompson's not happy with that. So at this time, we would request a court date for punishment, a plea in front of the court.
Are you wanting to do an open plea before the court and put on your evidence, or are you intending to plead guilty and do a sentencing hearing?
His just sentencing, Your Honor.
Okay, so it'd be an open plea to the court.
That's correct, Judge.
Okay. All right, we'll set that for March 30th would be the next available time that I could do that. Any objection to that time, Mr. Gimbel?
No objection, Your Honor. Would that be at 9 a.m. as well, Judge?
Yes, sir, that'd be at 9 a.m. And so let me ask you, Mr. Gimbel, are you requesting the preparation of a pre-sentence investigation report? Typically, the Community Supervision Department will meet with the defendant and conduct the pre-sentence investigation report to aid the court in ascertaining necessary information prior to assessing any punishment on an open plea of guilt.
I believe that would be helpful to everybody, Judge.
Okay, so I think we should be able to get that done by March 30th. I do not have my probation department in the hearing right now, so I will order that today. And so that means for you, Mr. Thomason, that a member of the probation department will come and visit you at the jail, and they will ask you information regarding your upbringing, your childhood, your parents. All of this information would then be put into a report, provided to you, provided to your attorney, Mr. Gimbel, provided to the state, and also provided to the court to help the court have more information about who you are and what you've done in your life and all the way up to your position on the alleged offense. And so, and I'm gonna ask the state to go ahead and prepare the plea paperwork for the open plea so that we can have that ready to go before the court, and I can review that and make sure that it's sufficient prior to March 30th.
Yes, Your Honor, we'll make sure that gets done.
Okay. All right. So we'll set this for March 30th at 9 a.m. and I'll order the probation department to come and see you.
Thank you.
You're welcome.
Your Honor, that's all I had this afternoon. Have the excuse.
Yes. Thank you, Mr. Gimbel. We appreciate you.
Your Honor, I see that we just have Mr. Adams left. Is that correct?
Yes. Is he there with you?
No, sir. I was hoping he was somewhere in your room with you.
No, I don't have him, nor do I have Mr. Beckham. I don't see either one of those gentlemen. Beckham did a motion to substitute.
We did. Did we grant it?
Mhm.
Oh, you did?
Mhm.
Okay.
I believe he was substituting for, just one moment.
Yes, sir. You need to visit Mr. Gimbel, because I can put this on mute.
If I could just
Ms. Tabraham's going to go call Mitch Adams and also Justin Beckham and try to get them online. So do we have Amy Davis pulled?
Yes, Your Honor.
We do? Okay. So we'll just see if we can get Mr. Beckham to zoom in and then Mr. Adams for Rochelle Kofer. Those are the only two that I have left. Is that who you have on your list?
Yes, sir. Okay. So Mr. Adams is only attached to one of the clients here, Mr. Beckham with the other one.
Correct. Mr. Adams was attached to both of them, but I believe that Mr. Beckham filed a motion to substitute and the court granted that. So
Okay, very good.
we'll just stand in recess and wait until they arrive.
Okay, thank you, sir.
Thank you. Good afternoon, Mr. Adams. How are you, sir?
Hello, Your Honor. Sorry for the delay.
Yeah, Ms. Tabraham said to give you her apologies, condolences on giving you the wrong Zoom ID.
Condolences. It's a conspiracy, I'm sure.
It's a conspiracy, yeah.
No harm, no foul.
All right, here's Ms. Kofer. This is cause number CR 2285 and CR 2320, State versus Rochelle Lynette Kofer. And we're set for pretrial, I believe, in each case. Any announcements, Mr. Adams?
Well, Your Honor, back at the end of January, I filed a motion for a competency evaluation for Ms. Kofer. And I've not received a report on the evaluation yet. So I'd have to reserve any pretrial announcements beyond that.
Give me just a moment. Let me go. I vaguely remember that, but I don't think I've done any appointments of any doctors. Let me see why that is. Did you file by chance, Mr. Adams, the supporting affidavit?
I believe I did.
Let me see here. I'm gonna look while you look.
It was file marked January 13, and it is notarized.
I believe that I reviewed the motion. I wasn't sure that it was sufficient, at least by my standards.
All right.
It says that the defendant advised that she has a history of diagnosed mental disabilities, listing those, and that she has received inpatient treatment at facilities on several occasions. Is there any evidence that you can tell the court that you've encountered during your representation of her that makes you feel like she's not competent at this time?
No, Your Honor. I think what caught my attention most was her telling me that she's been diagnosed with psychosis. I am like a lot of us. I have a sort of a layman's understanding of some of the garden variety mental conditions out there, like schizophrenia, bipolar disorder, things of that nature. I don't know what psychosis is really, and I don't trust any kind of research that I could do to find out. Not that it would be dispositive. So it was basically because of that I filed the motion out of an abundance of caution. When Ms. Kofer and I visit about her cases, I haven't seen anything or noticed anything to lead me to believe that she is pointedly not understanding what's taking place, or that is a bright flag of legal mental incompetence. I filed the motion basically out of an abundance of caution because I didn't want to waive that issue for her through my own inaction.
I understand. Typically what I do, kind of my court's policy is upon the motion for competency being filed, I look for an affidavit, a supporting affidavit that kind of lays out the grounds as to why we believe that, or while whoever may believe that the defendant is incompetent or suffering from some type of mental health disorder that prevents them from understanding the procedure, having an understanding of the different roles of prosecutor, defense, and court. So, the fact that someone's been diagnosed previously, that they've been hospitalized for it. While it's some evidence, what I look for before I expend the money to have a medical examination, a psychological examination of her or any defendant, is the attorney in discussing the case with the defendant exhibiting some type of behavior that leads the attorney to believe that they may not be legally competent. At this time, throughout your discussions with Ms. Kofer, do you have any concern that, understanding, I do understand your statement on, psychosis, but throughout your discussions with her regarding the discovery, do you have any concern that she's not in a position to assist you in formulating a defense, that she doesn't understand the role of the prosecutor, your role as her attorney, or the court's role as a court?
Judge, I think we lost Mr. Adams. I don't see him in the bar.
We sure did. Let's try it again. Where did you lose me at?
Judge, you were just laying out the criteria or the standard by which you would judge or evaluate a motion for a competency evaluation. I'm sorry, I'm having to attend on my cell phone and I got a call and it kicks me off.
No problem. Okay, so I'll just try to can it down a little bit. So what I look for on a motion for competency evaluation is, despite what you put in your motion, I believe that's some evidence, but I want to know if you believe throughout your discussions with the defendant that she's evidencing signs of mental illness at this time that makes her unable to assist you in formulating a defense, unable to rationally understand the different roles of prosecutor, defense, and court, understand that her past mental issues may be of concern, but do you believe that any of those are at this time affecting her ability to rationally perceive and understand the prosecution at this time?
That's correct, Your Honor. Besides the other issues that she mentioned were bipolar disorder, anxiety, and depression. I think this is just the comedy of errors, etc.
You don't have a position on the request, do you?
No, Your Honor. We would defer to whatever Mr. Adams, obviously he's the only one who's had substantial conversations with her, whatever he believes protects her interests going forward, we would be in agreement with.
So Mr. Adams, tell me, do you feel like you can advise Ms. Kofer and represent her throughout this case without a mental psychological evaluation? If the court were to defer and just table this motion until such a time arises that you believe that it's going to be necessary in order to continue, your representation, or do you feel at this time you need that mental examination so that you can represent her?
I tell you what, Judge, I'm not. I apologize for having to continuously turn around back and forth. I wouldn't have to do this if things were working right in my world this afternoon. I don't know that I have a plea offer yet from the state. And of course, I'm not by any stretch of the imagination indicating that by receiving one, that will dispose of the case. But if I could, if the state would send me a plea offer to resolve her two cases, then I think I might get a better feel for her ability to communicate with me in talking about that plea offer and what the options for it are. If I have any kind of question after that, then maybe I could revisit or re-urge my motion for an evaluation. But that might give me a good tool to either confirm or put to bed my concerns regarding her mental competence.
I think that's an excellent plan, Mr. Adams. I can't obviously make the state send you an offer. That's obviously up to them if they want to do that. So what I'll do is, if you're available on March 23rd, I'll reset this for an additional pretrial. And if you are able to speak with Ms. Cofer more between now and then with regards to a plea offer or anything further, then the court will re-entertain your motion. So I'm not gonna make a decision on that motion today. And so we'll just leave it pending, and I'll let you re-urge it on March 23rd if you're available.
Certainly, and I will make an effort to visit with Ms. Cofer again between now and then, with or without a plea offer, just to give myself a little more insight, a little more data to work with, shall we say.
And Ms. Heisel, not to try to commit you, to one position or not, but do you believe that an offer or two may be extended to Ms. Cofer?
Yes, Your Honor. This again, Mr. Woodwike's case, but notes in the case indicate that he may be waiting on some documentation for a Burke's notice. So I'm assuming that's why no offer has been extended at this time. However, I'm sure if Mr. Adams follows up with him, he could get an idea of what Mr. Woodwike is leaning towards in that direction.
All right, thank you. All right, Ms. Cofer, we're going to have another hearing on your case on March 23rd. Mr. Adams is going to come speak with you or set up a Zoom or something with you between now and then. And we'll see you back in March and talk a little bit more about your case, okay?
Yes, Your Honor.
Do you have any questions for me or Mr. Adams at this time?
Just one comment on as far as my medications are concerned, I'm not being treated for psychosis. And I know the issues that it causes, and things are happening because I'm not being treated for my psychosis.
Okay, I'm going to let Mr. Adams consider that, and maybe perhaps he can speak to the jail if it's a medication issue. I'm not sure that the jail can administer the medication that you need. That's something that the court's not aware of. So I'm going to let Mr. Adams see if he can tackle that with the state, okay?
Okay.
All right,
Thank you, Judge.
You're welcome, Ms. Cofer. We'll see you back here shortly on the 23rd, okay?
Okay.
And Ms. Cofer, I'll see you in the next couple of weeks.
Okay, thank you.
Yes, ma'am.
All right, thank you, Mr. Adams. I think we may have lost. Mr. Adams, you still with us, or?
Still here, Judge.
Okay, and I believe that's all that you have. Now, I think you previously represented Amy Davis, is that correct?
Yes. Did she hire counsel?
Yes, and you'll see her here in the jail court. She has hired Mr. Justin Beckham, and he had filed a motion to substitute counsel, and the court granted that motion. And let's see, I'm not in that case right now, but I believe that was back on the 16th. So if you'll go ahead and submit your bill, and I'm ordering Ms. Davis to make sure that the county is reimbursed as soon as possible for the payment of your bill, okay?
Very good, Your Honor. I appreciate that.
So you're relieved on that case, and we're going to move forward with Mr. Beckham.
Very good. Okay, Your Honor. Thank you.
Thank you.
Can I bring up something that is on the docket for Thursday, I believe?
I'll tell you what, yes, if you'll just hang around, let me go ahead and speak with Mr. Beckham and Ms. Davis. She's the last
Sure.
one in jail. And then if you'll stick around, we can talk about it.
Happy to do so. Thank you.
All right. Good afternoon, Mr. Beckham. How are you, sir?
I'm doing well, Your Honor. Thank you for waiting for me. I'm sorry I was double booked this afternoon.
Yes, sir. No problem. All right. This is cause number CR 20-328, State versus Amy Irene Davis. As you have heard, the court has granted the motion to substitute counsel. Mr. Beckham is now attorney for Mr. Davis, and Mr. Mitch Adams, the previous court-appointed attorney, has been discharged. And the court is ordering that Ms. Davis have on deposit with the pretrial release department sufficient money to discharge the indigent legal fees charged by Mr. Adams. Okay, so that's something that in the next 30 or 60 days, I want to make sure that Van County is reimbursed for those legal indigence fees. We're set for pretrial today. Mr. Beckham, I understand you just got in on the case. Typically, what I would do on pretrial is ask counsel if there are any contested pretrial motions, such as motions to quash or motions to suppress, that will need an evidentiary hearing. I believe probably at this point, you may not have been in the case long enough to come to that position yet. Is that true?
Well, Your Honor, I do still have some research to do. We have filed a motion to dismiss for factual insufficiency.
Okay. And so I guess you want me to set that for a hearing for you?
Yes, Your Honor, if you'd be so kind.
Yeah, and I believe that you filed that, at least I see it in my file as of today. Is that correct?
Oh, today, yes, Your Honor.
Okay, so we'll need to give the state opportunity to have notice and prepare for that. Do you anticipate that would just be legal argument, or would that require the testimony of any witnesses, Mr. Beckham?
It's possible that there would be testimony, Your Honor, that we would need to have.
Okay.
I think that it's just clear based on the documents that are an issue, but we may need testimony.
Okay. So what I'll do is I'll set Ms. Davis then for an evidentiary hearing on March 30th. And that'll be at 9 a.m. and we'll conduct that via Zoom unless there is a need for an in-person hearing. And if there is a need for an in-person hearing, the council will have to request that of the court.
Thank you, Your Honor. And I'm sorry, Your Honor, you said that was March 30th at 9 o'clock?
Yes, sir. Do you have any scheduling issues that day?
If I do, I'll move them, Your Honor.
Okay. Yes, it'd be at 9 a.m. on March 30th. All right. Once you get that notice, then Ms. Davis, you're free to be returned to custody, and we'll see you all on March 30th. Go ahead.
Your Honor, if I may, this prior counsel filed a habeas petition and a motion for bond reduction in this. My understanding is that Ms. Davis is being held on a $50,000 bond for this charge, and there's also a hold due to a motion to revoke that's been filed in a different case. My understanding is that the basis of that motion to revoke is primarily this new charge. However, there are some additional grounds for termination stated in the motion, including failure to pay supervision fines and fees. I've corresponded with Tyler this morning, who seemed to indicate that he would be agreeable to remove that no bond from the MTR if those fees were paid. And he's not here, and it was a short email conversation. So if I misstated that, Ms. Heisel, I apologize.
No, I believe that's correct. Mr. Woodwike let me know that if we could, as soon as we could confirm payment of those fees that she's behind on, that we would be willing to agree to set a bond on that motion to revoke, Judge.
Okay, and the court, upon an agreed motion to set bond being submitted to the court would consider that without hearing.
Thank you, Your Honor. With regards to the $50,000 bond that is currently set for this charge, it is one of the grounds of the motion for bond reduction that she's financially unable to make that. And so, Your Honor, I don't know if you're prepared to take that up at this time.
I'm looking for, did you say that was a writ? Or I see a pro se motion for personal bond or bond reduction filed pro se by Ms. Davis, which the court doesn't entertain when she has counsel, and she had counsel with Mr. Adams. You said Mr. Adams had filed a writ? Or a motion to reduce bond?
Well, he may be able to tell us exactly My understanding from my client is that there was a reduction, I'm sorry for misstating, after that pro se motion that was reduced down to 10,000. And I haven't seen that paperwork, Your Honor. But if I may just step over and get my phone, I can get you the date on that.
Well, I believe I have it. I believe I have it. Let me see if I can share my screen with you, and I'll show you what I've got. Signed this order on the 26th of January. And this is our present case.
Yes, Your Honor. I'm sorry, that application for written motion to set reasonable bond was filed on the 20th. So, and forgive me for coming into the case late. I did not realize that had been resolved down.
So it looks like it's currently set at 10,000.
And Your Honor, I have all of the money that Ms. Davis has in the world in my pocket. It's $750, and it's about to go to adult probation. And so, Your Honor, even at $1,000 bond premium is something that Ms. Davis is not able to provide.
I understand, but I believe that there would have to be another motion to reduce bail back down lower than 10,000. The state would need to get notice of that so they could prepare for that hearing. And
I understand, Your Honor. Again, to everyone involved, I apologize for coming in this late.
it's okay. So right now bail maintains at 10,000. If you want it lower than that, you'll need to file a motion to reduce bail and give notice to the state and then get a setting.
Thank you, Your Honor.
All right, so when that happens, we'll set that earlier than the 30th. We can set that quicker. And if not, then we will resume our hearing on your motion to dismiss on March 30th.
Thank you, Your Honor.
You're welcome. All right, if that concludes, then Ms. Davis, you're free to be returned to custody, and we'll be dismissed in the case. Ms. Heisel, there was a writ scheduled today with Mr. Weiner. I had a note that he is supposed to e-file a non-suit. I have not seen that. So apparently, he's not here to argue that, and apparently it's his intention on Marcus Ellison to not pursue his writ. So.
And Judge, Mr. Weiner and I had a conversation, and I let him know that there were 2 grand jury settings before the 90 days was up, and that we intended to indict it before that point. So I believe at this time he's going to abandon that, but re-urge it if that indictment does not get presented.
So is he asking to reset this for another date, or is he?
That I'm not sure. He didn't indicate to me that he was just going to outright withdraw it. But he's not here either.
But he's not here either.
So
I'm just going to go ahead and deny it, and then it can be refiled. Otherwise, these writs stay open on my civil side forever.
Okay. Yeah, not knowing his intention, I don't want to speak for him.
Okay. All right, Mr. Adams, what do you got for Thursday?
Yes, sir. It's Becky Ozuna that I'm bringing up. She was set for a revocation hearing about 3 weeks ago, I think. Got a plea offer from the DA's office, and you set her hearing for Thursday as a contested hearing. Should we need to have a contested hearing by that day? I had planned to visit with Ms. Ozuna last week. She's in the Henderson County Jail. And of course, due to the obvious weather conditions, I was not able to go visit with her. I wasn't able to get to her yesterday or today. can try to get over to see her tomorrow afternoon. But that being the case, it tells me that if I understand we have an agreed plea as of tomorrow afternoon, that wouldn't be soon enough for the paperwork to be ready for our hearing on Thursday. So I guess what I'm asking is, if I need additional time, and I'm not trying to commit you to anything. Let me put it this way. I anticipate that I might need additional time for Ms. Ozuna's case to advise the court as to whether or not we're definitely going to have a contested hearing or whether we have an agreement.
State, do you believe that we could get paperwork done between tomorrow and, I mean, we can get it done, I believe, on Thursday. If she wants to accept the plea on Thursday, I'm not concerned with getting the paperwork done. Are you, Ms. Heisel?
It shouldn't be a problem, Your Honor, as long as we know by tomorrow.
Were you planning on being present in Van Zandt County on Thursday, Mr. Adams, if you had a hearing?
I can be. That wouldn't be a problem because I've got a couple of other things set that morning. In addition to her matter. However, I take that back. As of right now, I've got a 9:45 hearing set here in Smith County that is going to be by Zoom. And I was figuring that I could juggle my Zoom hearings between your court and the other court. Because of what I have on my calendar tomorrow, I don't believe I could get over to see Miss Ozuna until 4:00 in the afternoon.
What if we move Miss Ozuna's case to 1:30 on Thursday? That way you could come over Thursday morning and you could talk with her about it. And that would give us some time in the morning to get the plea paperwork done for the afternoon. And if she rejects it, then we could go forward with the hearing. Would that help?
I have a 12:45 meeting on Thursday with a potential potential new business, and I'm loath to miss out on those.
So what do you propose? I don't want to pass the contested hearing date because I think that's the only way I can hold Miss Ozuna's feet to the fire. If I'm just being very honest with you,
I believe you.
I could move it to later in the afternoon. I don't know how many witnesses we're anticipating in the hearing or how long the hearing would take, but we could move later in the afternoon so you could do your 12:45 and then.
Would it be are you? I'm getting the impression that moving it to sometime next week is not on the table.
Well, no, because the next contested docket would be the 30th of March. So if I moved it, we couldn't take testimony. So
I will go see her some point tomorrow. And if we could, the later in the afternoon on Thursday, the better.
Is it, do you just need to speak with her about the plea offer?
Yes.
Okay. And I don't know if our jail may be able to, hook you up with a Zoom. I'm not sure.
Okay.
If that works or not, but obviously it's hard to discuss that over Zoom.
Yeah, I don't know. I don't know what Henderson County's doing in that regard. I'll try to find out. But if you're willing to set her for late Thursday afternoon, my meeting is at 12:45. I anticipate it's going to last about an hour, and so that 1:45. You make it if you set it around 3:30 or 4, I would be safely comfortable in telling you that I would be finished and ready to go by now. If I need to be there in person.
How long do you think the hearing would last if it's a contested hearing?
An hour tops.
Any witnesses other than probation officers? State?
Judge, again, this is Mr. Woodwike's case, but I don't believe so.
My only concern is I've got a 5:30 commitment that I have to be at on on Thursday. So we wouldn't have, we wouldn't have more than, I could set it, 3 is about as late as I'd want to set it. That way we would have 2 hours.
Would, I think I can, if my appointment shows up on time on Thursday, then I think I can make it over there by 3 o'clock.
Let's try that. We'll try
Okay.
to see how it goes. That way we can move forward one way or the other. And if she wants to accept it, great. Well, that'll give the state more time and the state should know, Mr. Adams, if you speak with her tomorrow, then you can let the state know and we can have more time on Thursday to do the paperwork. And if she doesn't, then we'll get started at 3.
Very good. And I have Ms. Hazel's cell phone number. I can send her a text message as soon as I know something tomorrow evening. So my midday appointment tells me he used to live in Portland, Oregon, and